Believe it or not, again, I'm a little different here. Look, I do not think that first degree is provable whatsoever. It requires premeditation, deliberate, intentional actions. And initially, too, the prosecutor didn't charge the first degree. It was the grand jury. When the prosecutor presented it to the grand jury, those lay people, the grand jury's a little loose too. It's not as they don't get the instructions like the petit jury does as well, and they found it on their own to go up to the first degree. So I just don't think that the prosecutor is going to be able to prove deliberate premeditation, intentional actions, and then it falls down to what was offered. So essentially what the prosecutor is doing is offering what I believe the jury would be the top count in the petit jury. And then there's this other option of the lesser included that the defense could try to argue that it was not extreme disregard for human life, because that's how you get to the second degree. It needs to be reckless actions showing extreme indifference to the human life. So with that being said, the state's got some good evidence, though. I mean, he's got a statement that says that he knew that the car would shut off 30 minutes. It was 109 that day, and she was in that car for 3 hours. But I could see the decision. It still will be a tough case for the defense, however. Well, look, I mean, it's the prior bad acts that we were just talking about, right? So generally speaking, we do not want juries deliberating on the guilt based on propensity to commit crimes or being a bad person. So there's a rule of evidence. Generally, it's 404B. And what that allows is for prosecutors to use those if it's narrowly tied and relevant to the particular case. Here, Julie, there's another wrinkle to this. And allegedly, I read reports that the defendant was in a convenience store earlier that day. He took 3 cans of beer into the bathroom, chugged 2 of them in the bathroom, and left without paying 1 on the day in question, also leaving his daughter in the car during that. So if that is true, and they could admit that particular evidence, that would be narrowly tailored to, and it would go to his state of mind. That is now under the influence, while also going in, playing video games, putting away garbage or the groceries, and then leaving the daughter out there. If true, if that's evidence that comes in, that's very, very difficult evidence for the defendant to explain.